Hello friends, welcome. Friends, yesterday I wrote an article and this article is about the digital competition law which has been posted in this website of Ministry of Corporate Affairs. Now, what is the purpose of my writing this article and why I am making this video? That's the whole point of this discussion. Now friends, in India, we have already seen and experienced that the app providers and the OS providers are in constant conflict. The app providers feel that the service charges that the OS providers are trying to charge from the app providers is not reasonable and that is impacting their business, and they are resisting it. And they have gone to the Competition Commission of India and as well as the Supreme Court for resolution, and various high courts were also involved. Now, when I went through this bill, I figured out that this bill actually can resolve this conflict very easily, and that is the whole purpose of this video. Now, if you look at this bill, and I'm pointing to two important clauses because I don't want you to get digressed and I don't want to beat around the bush and talk about things which are irrelevant in nature. I am going straight to the point. The point is that there are two different clauses. Clause number 13 and clause number 14 in page number 163. I believe that these are the most important clauses, the 13 and 14 clauses in this bill, which is going to lead to a resolution of this conflict. And let me explain how. Today, if you look at the current structure today, in which an app provider is distributing their apps to the common man, they are doing so using the OS provider's distribution platform, which is the Play Store. So I will focus my discussion on Google because that is the most important point of discussion today. Apple is not yet being discussed, though there is a case against Apple's on similar lines pending in CCI. So let's first discuss Google because Apple will also fall in line in a similar manner. Now, Google has a Play Store, which is an app store. Everybody uses Play Store. And if you want to distribute an app, you have to go through the Play Store. Now, once you are in the Play Store, you have to follow certain rules and regulations laid out by Google. What are those rules? There are certain technical rules that you have to follow in order to be qualified for hosting your app, and then you have to pay certain charges, service charges. Now, friends, these service charges are decided by Google. Typically, it is between 15% of the revenue, between 15 to 30% of the revenue that the app providers make, right, by selling their apps. So that's the service charge. Now, what happened was, when the case went to CCI basically said that since the OS providers are not giving the flexibility to the app providers to bill through a third-party billing system, they are acting in an anti-competitive manner. This is what CCI said. CCI basically said that the OS providers should give an option to the app providers to bill through a third-party billing system, right? Now friends, unfortunately, this did not resolve the issue because there were many other orders which were given by CCI in order to ensure that the app providers have more flexibility, but those orders were not that important as the order about the third-party billing system, but it did not resolve the issue. Now, what is this third-party billing system? App providers are currently billing through the Google's billing system, and therefore they are paying a certain service charge, which includes the billing system service charge and the service charge of hosting their apps within the Play Store. Now, when CCI said that third-party billing system should be allowed, Google allowed third-party billing system, but they did not drastically change the service charge, which is still, within the framework of 15 to 30% to the app providers. And how? Because Google just gave a discount of 4%, right, from 15%, so it made it 11%. And then the upper bracket was reduced from 30% to 26%. So the logic here is that since the app providers are now not going to go through the Google's billing system. They will go to a third-party billing system. The third-party billing system will charge a certain commission, and Google assumed that will be round about 4% of the revenues. And since they didn't want the app providers to be unnecessarily disadvantaged if they charge 15% and 30%, so they reduced their service charges from 15%, 30% to 11% to 26%, right? So this was the logic. Now the app providers thought that CCI order did not provide any benefit because on one hand they have to pay 11 to 26% service charges to Google, and then on top of it to pay another 4% to the third party billing system. So they ended up paying only same 15% to 30%. There were no changes as per their financial implication on the app provider or concern. There were no change, right? So that is where the conflict is. Now the app providers are going and talking to various agencies, education agencies. They are going to the High Court, they are going to the Supreme Court and saying that the Google's app charges are unreasonable. Now if you ask me, no court will be able to lend any resolution, including CCI. CCI will not go into the charges of the app provider is charging as long as those charges are not seen as exorbitant and detrimental to the interest of the market. Because if the market was having a detrimental impact, then those things has to be laid out before CCI that the market is shrinking, the app providers are not making any profit. Unless and until that is proved, nothing is going to happen either within CCI or within the courts. Now, only way to resolve this situation is to create an alternate market system on the OS provider's operating system. Means today we have an app or the app store run by the operating system, the OS provider. Like Google is having their own Play Store, we should have an alternate app store or alternate mechanism of loading the app on the OS, so that the app, instead of being within the Play Store, can be outside the Play Store and can be able to access all the core services which are being offered by the app providers, right? That is the whole intent. Now the CCI order unfortunately did not resolve that and gave that resolution, though it tried. There is a clause in the CCI order, I'll show it to you in my article which I wrote. I actually had written an article, let me see where the article is. So if you go to so this is the web page where I actually had written an article. So if you look at this web page, if I open this link, you will find that the April 20th order, there was a clause, right, which said that 617.3, which said that Google shall not deny access to Play Service API to disadvantage of OEMs, app developers and their existing potential competitor. This should ensure interoperability of apps between the Android OS, which complies with the compatibility requirement of Google Android forks. By virtue of this remedy, the app developer would be able to port their apps easily into the Android forks, right? But this was set aside by NCLT. But this, if you look at the language of this order of CCI, this exactly did not give the resolution. It was more than what typically the app providers needed. The app providers actually needed a side loading facility to be supported by the OS providers so that they are not disadvantaged when they are loading an app on a side loading basis, so that they can access all the core services which are offered by Google to the Play Store app provider, Play Store app, whoever is hosting their app into the Play Store. Means if I host my app within the Play Store, I am able to access certain core services within the Google's operating system. For example, I can access the CPU processing capability, the GPS location capability. There are various features which are the core service. They call it core services which are being offered by Google, and those can be accessed. Now, if I do a side loading, I should be able to access the same core services which Google is offering to the apps which are hosted on the Play Store, right? That's the whole intent. That was not enabled. Now, how that will help? It will help because if you have an alternate distribution mechanism of hosting your, or not only distributing your app, but hosting your app on the same OS platform side by side to the Play Store, then you can argue that Google should not be charging the same kind of service charges which they are now charging when the app is hosted in the Play Store, correct? So that is exactly what the DMA of European Union, the Digital Market Act of European Union, ended up accomplishing. Now, if you see this PowerPoint which I created, I'll go straight to the EU DMA. What EU has done, it has forced an alternate distribution mechanism and also forced through the regulation OS provider to give access to core service. So this is the Article 5 of EU DMA. If you go to the document, this document, the DMA document, no, not this one, this one. So here you will see the Article 5 here of the obligation of the gatekeepers. So you have to go down below, and if I just do a search, find, where is find? Here is find, and then I do a find and obligations, OBLIG obligations, and then there are so many obligations. So which it is? Just a minute. I have to go down. Anyway, so I have already extracted, because I don't want to waste your time. I have extracted the Article 5 obligation to gatekeepers. So which basically says that the gatekeeper shall allow the business user free of charge to communicate and promote their offers, including under different conditions, to the end user via core platform services or through other channels, or to conclude contract with those end users regardless of whether for that purpose they use the core platform services of the gatekeeper. The gatekeeper shall allow the users to access and use the core platform service, content, subscription, feature and other items by using the software services of the business user, including those end user required, such as such items from the relevant business user, without using the core platform services of the gatekeeper. Very complicated language. In simple terms, let me explain. You can sideload your app, right, and access all the core feature services or services of the OS provider. That is simple as that. Now, what is the Digital India Act is doing? It is doing the same thing. That is why I consider this very important. It is saying that the significant digital enterprise, which is the enterprise which is considered to be a dominant entity based on certain threshold and certain benchmarks, the Act will designate a particular entity as a significant digital enterprise entity, and they will be prohibited from restricting third-party application. Means systematically digital enterprise shall not restrict or impede the ability of the end user and the business user to download, install, operate or use third-party application or other software on its core digital services, and allow the end user and business user to choose and change default setting. You understand? So side loading is being allowed, which was basically kind of set aside by NCLT on the Google's order, which I showed you. And the app providers can do the side loading, but there is a problem here. The problem is that how would they advertise to the users that their apps are available for side loading? So what is happening is that they can be part of the App Store of Google, and within their app, they can inform the user that if you want to sideload the same app, which is part of the App Store, you can actually go to this particular website and download the app and do a sideloading. And that is called an anti-steering capability, which means that when I inform a user about sideloading or availability of the app in a different system, a distribution system, I actually have to provide a link or inform the user within my app, which was earlier prevented by the OS provider, that you cannot inform anybody about sideloading or availability of the application at a discounted price or an affordable price compared to what is being offered within the Play Store. So that is a capability which has been prevented. So earlier, the restriction which was imposed by the OS providers, now this clause number 14 will prevent that restriction. So you can inform. So you can do two things. You can be part of the Play Store, inform the user that you have got a side loading capability. You allow the user to go to the website, side load the app, and then you are out of the Play Store or the Apple's App Store, and you can sideload the apps and access all the core features and services of the OS providers right from there, which they are mandated to support. Now, that is where you will be able to get an alternate market to work in parallel with the app provider's existing Play Store, which will allow you to get a discount on the service charges which currently is being charged by the app provider, by the OS providers, right? So that's the only way. So example has been the Apple's recent announcement. If you look at the Apple, because of the EU DMA, Apple came out with the announcement, and this is where the notification is, and I read that notification to you so that you understand what Apple is saying. This is an old thing which they have already implemented use in iOS 17.4, which is saying that web distribution available in software update later this spring. This will let authorized developer to distribute their iOS apps to you user directly from a website of the developer owns and operates. See, Apple will provide access to API that facilitate the distribution of developers app from web, integrate with the system functionality, backup, restore, etc. So Apple has already allowed that. Now, not only it has allowed that, but it has a separate service charges which they call it core technology fee. So if you go to the core technology fee and you understand how that fee works, this is where the page is, and you will see that these charges which are demonstrated and calculated are going to be considerably less compared to what the charges that Apple is going to charge if you are part of their Apple's App Store, right? So this is how, so that is where this is important. The Digital India Act is important. These two clauses will be able to emulate the EU DMA provision within India, and that can be implemented immediately without going through the CCI's investigating process. Because why it can be implemented immediately? Because of this nature of the provision going to be ex ante legal framework, right? So even before the damage is caused, you will be allowed to force the OS providers to implement these features, which is quite different from ex post regulation, which is the current framework under which the CCI is investigating the OS providers, which is taking time, right? Now you understand what the point of this discussion is and how this discussion is important. So summarize, currently the market of the digital app service systems, their services are currently fragmented and not working properly. Why it is not working properly? Because there is a dominance of the OS providers, because they have a Play Store on which you are forced to be embedded within the Play Store if you want to distribute your app. Now, if you want to come out of the Play Store, there are no viable alternative available, because when you are going to come out of the Play Store to host the app in the operating system, just like in Microsoft Windows, you can host any app, anything, and you can get the core service, access to core service features of the processor right being within the Windows system. Similarly, you should have the capability to do that. So for that, the OS provider to support those access means they have to create an API, they have to support that API so that the core services can be accessed by the app when it is sideloaded, right? And that is where these two provisions which I talked about of the digital competition law is going to be critical. And that is where this is the most important part of the bill, by the way. There are many other things out of this 236 pages. I was able to extract these two things. One is the ability to sideload. Another is ability to inform the users that you have the capability of the distributing the same app, which is part of the App Store, through a web service where you can download the app and get a discount of the charges that you are currently paying for using that app. Got it? That's in short the this article is all about, which you can read. I'm going to paste a description of this, the link of this article in the description, and you can go through it and you can understand what is going on. And everybody should participate in the discussion, which is currently being hosted by Ministry of Corporate Affairs, so that you can submit your views. And this is very critical. And I can tell you that nothing is going to come out from the Supreme Court or anything unless and until this capability, which has been implemented in European Union, is similarly emulated in India for both Apple and Google and any other OS providers who currently have a marketplace of their own and doesn't allow a separate marketplace to be hosted in their OS system, just like the Windows and Windows operating system or the Mac operating system is enabling different types of apps to get hosted in the same operating system without restricting those apps to access the core features and services of the computer, right? That is what the game is. And I hope that you have understood what is going to come up and how this issue can get resolved. And I am happy and thankful of you following this video and till the end. And I'll come back to you with a new video next time. Thank you very much.